Welcome again to Washington Arbitration Week. This is day number, 4 of session number 2 today. And I have the pleasure of introducing, a line on the topic, but our wonderful moderator, Chloe Baldwin, will be comprehensively introducing the topic, but I wanted to take the opportunity first to thank Steptoe because they have been incredible supporters from the beginning of Washington Arbitration Week. And in this case, I would like to thank especially Chloe because the support is not only the hosting and being part of our circle of sponsors, but the support is really being involved in the process. That's what we really appreciate the most. We get the ideas of expert counsel and their team expert partners, and we work together to put some of the topics that are here. Some of the topics that are here have been proposed by others. Some of the topics that others are doing in other panels have been proposed by Chloe and her colleagues. So it works really like an organic process. So thank you, Chloe, for that. And with that, I would like to share that Chloe is a partner at Steptoe. So congratulations on that. And she focuses on international disputes and public international law, and in particular, the resolution of international investment disputes. She currently advises sovereign and non-sovereign clients in international investment proceedings, binational proceedings, and matters arising under the World Trade Organization, WTO. Chloe has represented sovereign states, state-owned entities, and private investors in numerous investment treaty arbitrations conducted under the International Center for Settlement of Investment Disputes, the United Nations Commission on International Trade Law, UNCITRAL, and the ICC rules. She has extensive experience in advising on matters of public international law, including the law of state and state responsibility and treaty interpretation. One of this panel is very close to my interest because it deals with the exceptions and especially some of the general exceptions in free trade agreements that question may not, could, shall not, or shall be applicable to investment treaties. So with that, I'll leave you to it, Chloe, and with an apology, I have to run and do some work, but the beauty about Washington Arbitration Week is that everything is recorded. You won't get the pain of my questions. You won't get the pain of my questions, but I'm looking forward to watching the panel. Thank you.
Thank you, Jose Antonio, and welcome everyone to Steptoe. We're thrilled to support Washington Arbitration Week and are very proud that we've been able to be involved and will continue to be involved as we can. My name is Chloe Baldwin. As Jose Antonio mentioned, I'm a partner in the International Disputes Group here. I'd like to welcome you to today's session on exceptions in investment chapters of free trade agreements. So I'm going to start by just introducing the topic, then introducing our wonderful panelists. You don't need to hear from me because they are fabulous, so I'll try and keep it short and sweet. But as we all know, investment provisions can be some of the most contentious components in free trade agreements. They are designed to promote cross-border investment by ensuring protection, transparency, predictability for investors. However, they also raise critical questions about a state's right to regulate in the public interest, particularly in areas such as environmental protection, public health, labour rights, national security. And this is where the exceptions come into play. They serve as vital safeguards to help balance investor rights with the sovereign powers of states, and they can determine when and how governments can legitimately deviate from their obligations under an FTA. However, there's always a but. The design and application of these exceptions raise complex legal and policy issues. They can, when they're applied too broadly or inconsistently, exceptions can risk being misused or abused, potentially undermining the confidence and protection that investors rely on. Conversely, overly restrictive interpretations may constrain legitimate regulatory action. These are thorny topics that go to the heart of state sovereignty as it intersects with investor protection. And as I said, we are very lucky to have an esteemed group of panelists here today to help us navigate the issues. I'm going to introduce them relatively quickly with just a high-level overview. This does not cover their many, many achievements, and I encourage you all to go and stalk them on the internet so you can see in full. But first, to my far left, we have Jim Mendenhall, who's a partner in Sidley's Global Arbitration, Trade and Advocacy Group. He has served as counsel in numerous investor-state arbitration proceedings and advised clients on international trade negotiations and trade policy. Jim previously served as the general counsel of the Office of United States Trade Representative, where he supervised US participation in the World Trade Organization, NAFTA disputes, and handled all legal aspects of US bilateral, regional, and multilateral trade negotiations. Immediately to my left, Analía González is the leader of BakerHostetler's Latin America arbitration and litigation team, where she focuses on investment and trade in Latin America, as well as issues pertaining to the environment, natural resources, and public health. She serves as an arbitrator in commercial arbitrations and has been appointed by Uruguay to the ICSID panel of arbitrators. To my far right, we have Sara Dangond, who is a foreign litigation associate at Curtis Millay Prevost, where she focuses on international arbitration and litigation. Prior to joining Curtis, she served as an advisor in the International Legal Affairs Bureau of Ministry of Trade, Industry and Tourism for the Republic of Colombia, and was an international economic law professor at Universidad de los Andes in Bogotá. And last but certainly not least, to my immediate right is Andrés Esteban, who is an international associate at Foley Hoag, where he advises and represents states before international courts and tribunals. He also previously served the government of Colombia, the State Legal Defense Agency, and the Office of International Affairs of the Ministry of Commerce, Industry and Tourism, representing Colombia in investor-state cases and international trade disputes, as well as advising the government on the negotiation and implementation of free trade agreements. So as that quick whip around will show you, we are lucky to have an impressive bench here today with experience that spans government representation as well as private practice. To get to the heart of the topic, we're going to hear from each of our panelists on a particular exception: national security, public health, the environment, and labor. After that, there'll be plenty of time for discussion and questions during the session and over lunch if you are able to join us later today. So with that, Jim, why don't you get us started on national security?
Sure, thank you. Can you hear me now? Okay, good. So I will talk about the essential security exception, which is a long, I could talk for hours on this, but I think I'm only allotted 5 to 7 minutes. So I'll try to make it as fast as I can. So the essential security exception, as most of you probably likely know, is an exception in investment treaties and in trade agreements that allows governments to take measures that are deemed to be essential to their essential to their security. Now, for a long time, these exceptions sort of lay dormant. There wasn't a lot of discussion about them. And part of that was because there was great concern that once you started down the road of invoking essential security, that may open the door too wide and would be subject, the invocation of the exception would be subject to abuse and allow states to avoid their obligations. That has changed in the last 10 to 15 years. And I think is going to change even more as we move forward. As of now, we have not a substantial body of jurisprudence, but we have a fair amount of jurisprudence on some of these measures. And I'll go through the different provisions, different variations of the provisions, and then wrap up with the discussion of what may be to come. So 4 broad points as we go through this. I think in determining whether the essential security exception applies and its scope, the text of the provision is extremely important. It was what go through the different variations. They're all drafted in different ways, and they all bring with them different interpretations. That won't be surprising to anyone. Point 2 is tribunals are are inclined to give great deference to governments in the interpretation and invocation of the exception, in part because there is something substantively different about this exception. It really goes more to the heart of sovereignty, perhaps level of importance than some of the other exceptions. Third point is, despite the deference that they give, they will go kicking and screaming to avoid trying to make the exception entirely self-judging. There was always an inclination of tribunals to provide some degree of oversight. This question of whether the invocation of these exceptions is self-judging or not is at the heart of this discussion. I was hoping some of the State Department personnel would stay here because I know this is near and dear to their hearts, but they seem to have decamped. Hopefully not for, unless there's maybe there's one that I'm missing. I'd be interested in hearing their views on this. And then the last point is, generally speaking, when tribunals have talked about these exceptions, it's clearly not limited to sort of military security. The tribunals have been very open to accepting the idea that economic security can play a role here. And I highlight that because I want to come back to that at the end, given the current environment. So let's start with a rapid survey of a couple of these provisions. So what I have on the screen, and sorry, my screen is a little off here, is a provision from the U.S.-Argentina bid. And I flagged this because there was a fair amount of jurisprudence over what this provision actually meant. And I'm not going to spend a lot of time on the facts of these cases. But the upshot of the jurisprudence surrounding this provision is, this provision as written was deemed not to be self-judging because there's nothing in the provision that would lead a tribunal to that conclusion. The other notable part of this definition is that there is no definition of what an essential security interest is. So a number of tribunals tried to find or root that definition in customary international law and necessity. Annulment tribunal said, no, that's not the way to do this. It has to be judged based on its own, on the text of the agreement, the text of the provision, and it does not carry with it all of the bells and whistles that are necessary to invoke the customary law doctrine of necessity. So what does essential security actually mean, given the lack of definition, is still hotly debated. All tribunals have really said so far is that it has to be essential and it has to be related to security. Fair enough. What does it mean in practice, I think is very difficult to generalize. But it has to be something that is elevated above other societal interests. You know, it's not just a public interest exception. It's something that is really security related. Now, what I have on the bottom of the screen is an excerpt from the CMS decision, which I include only because they contrasted this decision with with an analogous provision in the WTO GATT context, and they said clearly, in the GATT context, that provision is self-judging. I'll talk about that in a second, in contrast to the BIT. So let's talk about what's in the WTO. So the WTO, of course, is a trade agreement, but I raise this exception because a lot of investment treaties include security exceptions that are modeled on this, right? So this provision is different from the Argentina BIT because it expressly says that nothing prevents a party from taking an action which it considers to be necessary. Question is, does that language make this provision self-judging? So it considers necessary for the protection of essential security interests relating to the three items in Romanets 1 to 3. So there was a debate in the WTO about whether this is self-judging because of the inclusion of the words it considers. The upshot of those decisions is that whether or not it considers necessary is self-judging. What is clear is that Romanets 1 to 3 are not self-judging. So that phrase it considers doesn't really extend beyond the term necessary. It doesn't go necessarily to the definition of essential security interest, and it doesn't go to Romanets 1 to 3, which gave the WTO panels an out because they were able to say 1 to 3 is objective, and we get to decide on that. So this is not self-judging at the end of the day. So which raises the question, okay, what happens if you don't have those Romanets 1 to 3? What I have is a provision on the screen from the CPTPP, which is very similar to the WTO provision, but without the Romanets. And so is this self-judging or not, I think remains sort of up in the air. What is clear is that governments are acutely aware of this debate And they really, well, some of them at least, really want to wrest this authority back from the tribunals and make it a truly self-judging provision. So what I have on the screen next is a provision from the US-Colombia agreement, where it's similar to the CPTPP provision, but then adds a footnote that says, for greater certainty, if a party invokes this provision, the essential security provision, the tribunal or panel hearing the matter shall find that the exception applies, right? So this was interpreted by one tribunal last year, and they said, okay, that footnote doesn't really mean anything because it says for greater certainty, which means it's not changing anything substantively. And it also says the tribunal has to make a finding, right? So we have some discretion to figure out whether this actually applies or not. They did say this provision is self-judging, but then they went ahead and applied a standard of review to determine whether or not it was invoked properly. And basically what they said is, if you invoke, we get to review at least whether the invocation of this provision is in good faith or not. Whether that was what the parties intended, I think is debatable, but they said this is not an automatic provision where we just have to dismiss the dispute once the provision has been invoked. They said this provision does not make the provision non-justiciable. And they contrasted it with a separate provision in the Singapore-India Treaty, which expressly said in a side letter, this is non-justiciable. So the question is, whether in the future that is going to be the direction of any future agreements that are negotiated. So in the interest of time, I'm just going to skip to the crux of this, which is what I have on the screen are a number of different executive decisions made by the Trump administration. These are in the context primarily of trade, not investment, but I'm raising them to give you a sense of how the US at least has interpreted essential security in the last year, right? And they've said things like importation of wood products, including things like derivatives like kitchen cabinets, is an essential security matter, right? They invoked essential security when or to justify the Liberation Day tariffs earlier this year, and they said these trade deficits present a deep essential security concern for the United States, or national security concern. In the America First investment policy, it issued in February, there was a flat declaration that economic security is national security. Now I'm not going to take a view on whether these are right or wrong, or whether the invocation is right or wrong. But two points. One, if the future is that these provisions are non-justiciable, this is the kind of thing you're going to get. Even if they're not non-justiciable, the question is how a tribunal is going to interpret this in the context of whether this is in good faith or not. Is it truly, and I think that's a more difficult question, right? Is it really in bad faith to say economic security is national security? Is it in bad faith to say the US has to create an industrial base that's focused on semiconductors or whatnot? These are very difficult questions. And I think as we're going to see, and there's not a lot of guidance on this, right, going forward, but I think we're going to see a fair amount of jurisprudence in the future that elaborates on the meaning of these provisions. So I'll stop there. Thank you.
Thank you, Jim. That was very interesting, and actually touched upon one of the big questions I had was, we're seeing a lot out of the US administration right now, and other countries are following suit as a result of, the geopolitical tensions, and increasingly national security, essential security has become a defense. There are still cases in the WTO where the objective self-judging nature is being hashed out between the parties. Do you think, as we project forward, and although these are trade measures, they will affect some investors to some extent, and if we assume disputes are going, do you think, looking at WTO judgments of how they've considered this, if the provisions are alike, which to your point, there are various iterations, how do you see that playing out as between countries? If the trade issues on national security are starting, do you think that will ultimately impact how an investor state tribunal will consider it?
Yes, I think there's a lot of cross-fertilization between the interpretation of the essential security provision in the WTO and in the investment treaties. Although it is very provision specific, right? So not all of these treaties, copy what's in the WTO, which limits the extent perhaps of the cross fertilization. But I do think as a political matter, we are going to see more countries invoking essential security with respect to measures that 20 years ago they never would have dreamed of invoking essential security, right? Because the U.S. has led on this, and this is now the accepted. Well, accepted is probably an overstatement. This is at least accepted within the U.S. government as an appropriate approach. So you're going to see a lot of that. What jurisprudence you're going to get in the WTO itself, I think, is unclear, given that the appellate body is not functioning and you don't have binding decisions anymore. But nonetheless, I think what panels say about it is going to influence what's happening on the investor state side. I think, honestly, part of the tone of my comments has been sort of skeptical about the invocation of these provisions. But I do think these provisions are like an essential safeguard, right? There has to be an outlet. There has to be an out to deal with some of these measures. And part of the problem is that the WTO agreements and some of these other agreements are sort of seen by some as like the final, as the end point, as a comprehensive set of regulations that will cover everything, and they're really not, right? I mean, they cover certain things, but they don't cover everything. And they may need to change over time. And I think part of what we've seen has been a frustration by many with the current system and sort of portraying the WTO agreements and some of these investment agreements as if they were statutory codes, like covering every aspect of activity. There needs to be an out. And the question is where you strike that balance.
Great, thank you. And I could go all day on this, but I'm going to hold myself back because there are a number of cross-cutting questions that I want to come back to. But let's move now to Analía to talk about public health. I confess, my first foray into investor state arbitration was a public health measure in Philip Morris versus Australia, the government of Australia. And I know you have a similar background, so please.
Well, thank you so much. And thank you very much for inviting me to this panel. There you go. Okay, thank you. So thank you again. So I think that the discussion goes to the heart of the balance between protection of investors versus public health and the right to regulate in the interest of public health. And I think that this discussion is interesting and not only theoretical for me, just because of, as you mentioned, I had the privilege of represent Uruguay in the Philip Morris versus Uruguay case. And I think that case, together with the Philip Morris versus Australia case, goes to this issue of how free trade agreements after these decisions frame these carve-outs in investment treaties. And so I would like to start with the Philip Morris versus Uruguay case. As you know, in 2010, Philip Morris sued Uruguay in an investment arbitration under the Switzerland-Uruguay bilateral investment treaty, challenging specifically two measures. One is the single presentation requirement, which was the requirement that they could only sell one variant under each of the brands. And the second one was the requirement that 80% of the packaging should be devoted to the label warning. And after 6 years of this arbitration that lasted 6 years, in 2016, the tribunal issued the award, and it was dismissing the claims, Philip Morris claims. And also, I think that there are two important highlights of this of the tribunal award. First is the recognition also that the Uruguay measures were legitimate exercise of state police powers to protect public health. And the second one, I think, is that the Uruguay measures were consistent with their obligations under international law, and also did not violate the provisions of the treaty in terms of fair and equitable treatment and their expropriation, etc. So it is, I think that this decision was a victory for not only for Uruguay, but also for this principle that public health deserves a special protection by governments and the right to regulate in the interest of protecting these public interests. So what happened? It's important to know that this regulatory chill that we have sometimes heard when discussing the evolution and the reform of investment protection. This did happen in the context of tobacco measures. The mere filing of the Philip Morris case in 2010 created that effect of other governments that were looking at what was going on. Uruguay, I'm not sure if you know, but at the time that Uruguay in 2006 took those measures, Uruguayan president was an oncologist, Tabaré Vázquez. So Uruguay was ahead in the protection of public health, probably because of the background of the president of the republic at that time. And the international community, I think, and the countries were trying to advance also on the protection of public health and going towards similar measures that the ones that Uruguay took. And the mere filing, as I mentioned, of the Philip Morris case create this effect of some of the countries of maybe holding and waiting to see what was going to be the result of this case, and also the Australia case, to legislate and to enact legislations. And I think that this context create the perfect scenario for government after the decisions to see how they could frame the protection of investment in investment treaties to protect those public interests. And perhaps the first reaction was with the CPTPP, which was the most direct policy response, that include Article 29.5, tobacco control measures. That is a specific carve out for tobacco control measures. Which I'm sorry I don't have a slide, but I'm gonna read it. A party may elect to deny the benefit of Section B investment with respect to claims challenging a tobacco control measures of the party. Such a claim shall not be submitted to arbitration if a party has made such election. So it's pretty straightforward. If a party elects this mechanism, then any tobacco control measure should not be protected or subject to the provisions of the bilateral investment treaty. And I think that, so that was a specific carve out on tobacco control measures. We have a similar example and even more specific with the Australia-Hong Kong investment treaty that also exclude tobacco control measures from ISDS. And I would like to read it because it's amazing in the level of detail. It says, no, yes, and this was a reaction actually to the Philip Morris versus Australia case in 2019. No claim may be brought under this section in respect of a party's control measures of tobacco products, cigarettes, imitation smoking products, and other smoking products such as electronic nicotine delivery systems and electronic nicotine delivery systems, including electronic cigarettes. And then it says, a control measure of a party includes measures with respect to production, consumption, importation, distribution, labeling, packaging, advertising, marketing, promotion, sale, purchase, et cetera, et cetera. So it's very, very specific, and it's a specific carve out to an industry. And it was, again, a response to the Philip Morris versus Australia case. So what other type of response or responses we found? Perhaps not carve outs to tobacco control measures, but carve outs to health measures in general, more perhaps horizontal, including health and environment. And as such, we have, for example, the USMCA that not only narrowed the scope of ISDS in general, but also include Article 1416, which mentions that nothing in this chapter shall be construed to prevent a party from adopting, maintaining, or enforcing any measure otherwise consistent with this chapter that it considers appropriate to ensure that investment activity in its territory is undertaken in a manner sensitive to environmental, health, safety, or other regulatory objectives. And the USMCA also has Annex 14D with respect to indirect expropriation, which also mentions health, and it mentions that non-discriminatory measures that are taken to protect public health, safety, and the environment do not constitute indirect expropriation except in rare circumstances. So it's very telling that it devoted a whole annex to regulate the indirect expropriation, and it did include that those type of measures could not constitute indirect expropriation. In addition, we also have perhaps specific recognitions of the right to regulate in some treaties, such as the European Union Canada Treaty that reaffirms the parties' right to regulate to achieve legitimate policy objectives such as public health, safety, environment, and clarifies that expectations do not constitute breach of the investment chapter. Adverse effect on profits or expectations do not constitute breaches. And similarly, in the European Union Vietnam Investment Protection or Agreement, or the European Union Singapore or Chile Advanced Framework Agreement, also includes right to regulate clauses very similar to the one in the CETA treaty. So what does this trend show us? First, I think that litigation can impulse treaty renegotiation. For example, I don't think that without the Philip Morris cases, both of them, the governments would have been so quickly in perhaps amending their or renegotiating their free trade agreements. Also, I think that the trend is towards the right to regulate after those measures. And I think that the balance and that specific carve-outs are rare, but they exist. And the question is whether in the future we'll see those specific carve-outs with respect to other issues, such as climate change, for example. We'll have to wait and see. But I think that as practitioners and users of the system, I think that the challenge is to continue to hope that we find this balance between the right to regulate and the protection of the investors, and that such the modification of treaties continue to evolve in a legitimate way that is fair to both investors and the state. Thank you.
No, thank you. That was very interesting introduction to the world of tobacco carve-outs and public health, which is very, very complicated. I mean, I have many questions and I will try and contain myself. I mean, these carve-outs, as you mentioned, happen very quickly after litigation. Do you think that they have deterred cases? Do you think that other states will kind of adopt similar carve-outs, or do you think it was more symbolic in reaction? And I guess the second part of that question is, going forward, you mentioned climate change, alcohol has been floated a number of times in various jurisdictions, food and labeling. If we start getting carve-outs for everything for political reasons, how does that compare against general exceptions and, of course, balancing against the rights of investors?
Okay, I think that, what has happened in the last perhaps 10 years has shown that yes, I mean, they will continue to be included in my opinion, in treaties, these specific carve-outs. I think that, of course, there is a risk it could be a risk of fragmentation if these continue to evolve and then we start to see specific carve-outs for different industries, and that could be an uneven protection of the investment depending on the sector. But I think that even though for example, the right to regulate has been already recognized by tribunals, Philip Morris and other tribunals, I think that the carve-outs are still needed to specifically to defer, the investors from or to protect the governments to be dragged into these long, lengthy, and costly arbitrations. So, in my opinion, I think we will continue to see these carve-outs in future treaties. And also with respect to health, not only we have the cases, but then we also had the pandemic. We have COVID, right? So I think that there were a lot of governments that were needed to take measures to protect the population in light of a worldwide pandemic. So that was a lesson, and I think that it is possible that they will continue continue to be included, not only, and also, as you mentioned, in other sectors such as climate change, alcohol. We'll see more of that, I think.
I think you're right. You mentioned, and then I promise we'll move on, but you mentioned the right to regulate several times. And, having just heard Jim's discussion of the self-judging nature of the essential security interest, that doesn't usually happen as much in public health carve-outs. Some language, as you've pointed out, is stricter than others, but how does a tribunal deal with, issues of proportionality? What sort of deference should they be, or have they been, not should they, I guess, have they been giving to states when they claim it's their sovereign right to regulate?
Well, I think that a key aspect is, of course, the tribunals will analyze the measures to see if not only if the measure was non-discriminatory, but also that is not an arbitrary measure. I mean, in the example of the Philip Morris case, I remember that it was very important to show the tribunal that these measures were based in scientific evidence that, two different variants of cigarette, selling those two different variants could give the impression to the public that one was maybe healthier than the other. Mm-hmm. So it was a very important to demonstrate that the measures were not arbitrary. And so there is a difference, but it is clear that the tribunal will do a very in-depth analysis of the measures to make sure that they are not arbitrary, non-discriminatory, etc., and that the measure was taken to go from A to B, to get to protect a public health objective. And so there's going to be a great monitoring of the measure and how it was taken.
Wonderful, thank you. Well, I'll let you off the hook for now. I'll let you drink some water. Andrés, if we can move to you, and perhaps to start, you could give us a broad overview of how environmental exceptions are framed in investment treaties and why they've become increasingly important in the last decade. I note your experience with the government of Colombia, which of course has been subject to a number of cases that raise these issues. So please take the floor. It's just on the top.
Yep. Okay. Thank you, Chloe, and good morning, everyone. Thanks to the organizers of the event and to my colleagues. I'll speak about the environmental exception in investment agreements. I will first start with a quick background, then I'll talk about the practice of the tribunal, and particularly we can discuss this Eco-Oro case, where I had the privilege of being part of the Colombian team, facing this kind of exceptions. And finally, I'll delve into recent developments underway looking forward. For decades, we've witnessed fundamental tensions in international investment law. On the one hand, investment treaties protect foreign investors through substantive standards like fair and equitable treatment, protection against expropriation. But on the other hand, states retain something we've been talking about a lot today, is that sovereign right to regulate in the public interest, including environmental protection. Traditionally, bilateral investment treaties were largely silent on environmental matters. The assumption was simple: investment protection provisions would not interfere with legitimate regulatory measures. However, as tribunals awarded damages against states for environmental regulations, particularly for mining restrictions, the need for explicit environmental exceptions became undeniable. We've seen different approaches, as we've talked here. We've seen treaties including or incorporating provisions similar or identical to the GATT Article 20. We also, that it includes this particular disposition of allowing measures necessary to protect human, animal, or plant health of life. And more recently, treaties added specific environmental carve-outs and policy space. We've seen this in the current negotiations of the ECT, and we've seen this also in the current task of the USMCA. However, when we see the data, the picture is a little bit tricky, because according to UNCTAD, only about 10% of all investment treaties.
Sorry,
contain
there's a
words.
spider, but I'm Australian, so it actually doesn't bother me. But we don't want anyone to get hurt.
Sorry.
Might be in your first
Yeah, I know.
Go ahead.
Sorry.
Well,
Thank you.
after the spider, so thanks. According to UNCTAD, and this is really interesting, is that only about 10% of all investment treaties contain an environmental exception. So even if we're discussing, I mean, this trend, and we've moved towards that balance between the states' right to regulate and the investment protection, only a small portion of the whole set of treaties that it's out there includes these kind of exceptions. So this exception in practice have informed arbitral tribunals' interpretations of standard of protections, but only at least in one instance, in even versus Costa Rica, the tribunal said that this exception was capable of imposing treaty obligations upon investors. However, in the rest of the case and most of the cases, tribunals have considered that such clauses do not automatically override substantive protections and are to be interpreted on a case-by-case basis. As we recall here, we have the Infinito Gold case, the Eco-Oro case, the Red Eagle exploration case, Montauk metals. And in all, in particular, I remember being in the discussion of the Eco-Oro case when Colombia, as a lawyer with WTO background, for me was straight. Is if there's a measure and that measure is incompatible with the treaty, then you go with the exception. If the exception is applicable, it justifies the measure. Therefore, there's no compensation. However, it seems to be that WTO logic is not. It wasn't that straightforward for investment tribunals. For me, it was, and I remember having this conversation as part of the Colombian legal team with the law firm representing us, also helping us in this case. And it was difficult for me to understand whether there was a point in the discussion where we were even discussing that compensation was an alternative, even if the exception applies. And we ended up seeing the tribunal deciding that even if the exception applies, there should be compensation. Actually, the tribunal ended up saying that there was a violation, the exception didn't apply, but even if it applies, it would end up with compensation. We know all the debate that came after this, because it was kind of, and I think it was this message of the tribunal or all this noise that made in the international community saying, we are not giving the states their particular tools to defend their right to regulate. And more importantly here, as you might remember, there was an interpretative declaration made by Colombia and Canada, particularly granting more relevance to the environment when it comes a dispute, an investment dispute. So after this, we've seen some renegotiation, some ways to try to deal with it. With particularly, the first question that came after that was, what's the particular weight of, or the particularly usefulness of having interpretative declarations? After that, I think this is what is impulsing carve-outs, because we don't get into the exception. Let's make it into the carve-out, and the tribunal has to go first to the carve-out and then see if the carve-out is not applicable. Then you can see if actually there was a breach of the obligation. But however, I think this might change. We've seen recent developments, And as you all know, in July 2025, the ICJ issued its advisory opinion on the legal obligation of states in respect to climate change. The ICJ affirmed that states are under binding obligations to ensure the protection of the climate system and other parts of the environment from greenhouse gases. These obligations arise under a comprehensive framework of international law, and the states are required to act with due diligence in addressing climate change. This also, the ICJ stated that the right to clean, healthy, and a sustainable environment is an autonomous human right that is essential for the enjoyment and realization of other human rights. And it also imposes that states must take measures to protect the climate system and the environment by imposing also regulation of activities of private actors. So I consider that the future of the exceptions is basically, we have like three key developments. First, states will continue to focus on treaty drafting. I mean, treaty drafting must evolve. We need exceptions that are robust, clear, and specifically tailored to contemporary challenges like climate change, or we might see more carve-outs with climate change provisions. Second, tribunals must develop coherent jurisprudence that respect both investment protections and environmental imperatives. And third, I think this might happen even if we are here talking about exceptions, but the proliferation of carve-outs from substantive trade protections, I mean, mostly like performance requirements or in expropriation clauses or in MFN clauses are to be more seen in the future.
Thank you. So you mentioned climate change a few times, and Analía did as well. Climate change has been a controversial topic. Obviously, the Paris Agreement is in place, but how do you think investment exceptions will interact with climate change, and what role do these broader, the ICJ decision, these broader agreements on climate change, how do you think that will factor into exceptions going forward?
I mean, I think this is forcing the reconsideration of the exceptions. I think what we've seen in recent treaties is that those treaties are responding to climate change problem issues. The ECT modernization process includes this proposal to protect climate measures. Also, the European Union's recent approach explicitly recognized the Paris Agreement and the right to regulate for climate objectives. So I anticipate that this will make aligned investment arbitration more closely to global climate change objectives. Like we've seen tribunals having more, or we all having more awareness of what's happening and how the treaties may evolve with those conversations.
Well, watch this space. One other question, to draw on your experience with Colombia and the Eco-Oro case in particular, I think your looking forward points were excellent and right at the crux of it. But I guess, the compensation issues that you mentioned in that case, how should states, can they manage that once an exception has been invoked? How do you see that playing out in potential future disputes?
It's still striking to me.
It's a therapy session.
Yes, it's still striking to me. But I think, what I've seen is there have been some discussions in some renegotiations. Particularly, it took my attention, the Morocco BIT model that says that nothing in this agreement shall be, when they were drafting the exception clause, they included nothing in this agreement shall be construed to require a party to pay compensation when exceptions apply. However, they have not been able to include this particular language in one of their treaties. But I think, maybe if we're talking about going with robust, clear wording of the treaties, this might be an option. And also, I think it's important, and even if the tribunal in Eco-Oro didn't took it seriously, those, interpretative statements made by states that are the actual owners of the treaties are remain being extremely important. Particularly if we try to push for a correct interpretation under BCLT Article 31, even if this is a or subsequent practice or subsequent agreement, but states should keep pushing for those interpretative statements to make it work.
I wasn't aware of that language in the model bit, which is really, really interesting. And we may see that coming forward as a result. We were talking before about states' reaction to litigation, and I could see that being something that comes up too. So thank you. It's very interesting. We're now going to move to Sara, who potentially has the hardest job of the exceptions that we're discussing, because national security, public health, environment have all had cases addressing them. Sara is going to tackle labour and exceptions for labour. It's also a hard job because it intersects with a lot of the issues that we have been talking about, potentially public health, human rights. So thank you for taking on this topic, first of all. But please, why don't you begin by outlining labour exceptions and talk us through it?
Thank you, Chloe. And yes, you're right. This is one of the most difficult issues because there's not much. So preview, we don't have many exceptions specific to labor rights in our current investment treaties. And this is kind of off because I think that we can all picture a situation in which a state, perhaps in the mining sector, withdraws a social license to a project because of issues with perhaps child labor or working hours. So I think this is something that we can all picture. And in particular, in the mining sector, we know that there's like documented issues on child labor, equal pay, but we don't see these translating into the investment treaties that we have, and much less into the world of disputes. So what I'm going to try to unpack today is, first, we don't have much, but if we were to have, what would be the implication for economic globalization and for the configuration of supply chains? So labor provisions are largely absent from the investment treaties in the exceptions clauses. If you see the USMCA has an entire chapter discussing labor and the relevance, the recognition of ILO standards. However, if you go to the USMCA, to the chapter on general exceptions, or to the investment chapter, the general exceptions provisions, you cannot find nothing specific to labor. Some treaties do have these labor standards as part of their exceptions, but if Andrés Esteban said that it's 10% of treaties that have environmental exceptions, I believe that for labor it would be around 1% of the treaties. So it's really not much. But we do have one treaty that is well ahead of its time, and it's like a fast forward into the future. Which one is this treaty? That is not enforced yet, but is the protocol on investment on the protocol on investment to the agreement establishing the African Continental Free Trade Area. Because the name is that long, I'm just going to refer to it as the African Protocol. The African Protocol not only includes labor as an exception to the obligations of the state vis-a-vis the investor, but also incorporate ILO standards and labor-related obligations to the investor. So potentially states could have counterclaims related to child labor and equal pay and labor standards against the investor. And also, this treaty incorporates an obligation for state parties to maintain and increase their labor standards. So we have this like fast forward agreement. And what I want to do today is try to unpack what these sort of provisions might mean for economic globalization and the configuration of supply chains. So we know that investors in a globalized world with free trade consider many factors before deciding where to invest. Which one is going to be the host state of their investment? One of these factors includes labor standards. So potentially, investors may have an incentive to go to states with low labor standards in order to have a most cost efficient operation and just save a bit of money in crazy rigorous labor standards, and then just export their goods to other countries and looking for other markets. This is the magic of free trade. You can go everywhere with your investment, and then you can take it back to your home country almost without a prohibitive fee, because free trade works, and we have containers, and we have all sorts of ways of communicating. So, what would happen to the investors' decisions on where to invest if our investment treaties have the obligation for states to increase their labor standards and provide this ample leeway via exceptions for states to take stringent measures against investors due to labor issues or concerns? Will these provisions impact the configuration of supply chains? I don't know, potentially they might. And this is just a showing of the north-south divide we have on this particular point. If you don't like the north-south divide terminology, that's fine. We could also refer to this as the high income, low income, middle income states, like conflict, if I may. But usually high income states have voiced the concern that free trade and global economic globalization, which does not only imply the movement of goods, but the movement of capital and investment through states, would suppress their domestic wages. It would affect their domestic industries because they would have to compete with goods produced elsewhere with lower environmental standards. Another concern voiced by high income states is that their own investors are going to go elsewhere to take advantage of these low regulatory standards, and in particular low labor standards. But then you see what the concern that has been voiced by low and middle income states, and is you're taking these measures as veiled protectionism to marginalize us from the global economy, and only by way of participating actively in the global economy, we are going to naturally achieve a level of development that will ultimately result in the labor standards that you ask for. So you can see this core substantive north-south divide in terms of labor law standards. The only organization that we have, and that is like currently agreed to even in investment treaties and FTAs, is that the ILO is the standard setter for labor standards. However, when you see the ILO agreements and standards, they also grant a lot of leeway for states in labor matters, because this is and has been historically understood as part of a state's sovereignty. And this is one of the historically very protected as a sovereign power, a place in which you can exercise your sovereign power. So I would just call for all of us that are going to be future drafters of investment agreements and perhaps potential disputes that you might receive regarding labor standards, to think about the big picture of these provisions in the framework of economic globalization right now. And why right now? Because as of today, economic globalization is in a decisive moment. And this decision is well underway in the trade area. And we see now the United States taking a lot of unilateral measures to address this issue. And the fundamental issue is, how can we have a fair economic globalization? So fair movement of and free movement of goods and capital investment. How can we have this model of economic globalization, free trades, free movement of people, of capital among states with different views on these core fundamental values, such as national security, the environment, labor, and also with the obligation to protect their local domestic industries? So this is one of the most existential questions that we should all be grappling with at night, because states are doing so. And you see in the liberation tariffs that Jim mentioned before, one of the rationales behind the liberation tariffs was that economic liberalization and economic trade in these terms are suppressing the wages in the US. So you see that labor law is at the core of the fundamental issues that we're dealing with in economic globalization. And we are at a really good moment of pushing forward whatever we think might be the best solution to this existential issue. And we have the example with the African protocol. So let's see.
Well, I need a cup of tea and a lie down after that, because that is existential. I have one kind of specific question that I would pose to you in terms of the investment agreements and your call to action as we move forward. You mentioned mining at the outset of your presentation, and we're seeing increasingly requirements for a social license to operate. To what extent do those social licenses to operate encompass labor-related issues? Are those types of requirements better than trying to put, not better, but more effective than trying to put in a general labor under a general exception or a carve out, or how do you think that would work in practice?
Maybe, but this is because of my personal views on what law should be. I don't think that the solution would be incorporating more provisions into treaties, because this usually does not work as much. If states arguably want to impose one of these measures via social licenses or whatnot, they might find enough tools in existing investment agreements to do so. For instance, like in this just catch all regulatory exceptions. And also, and this is part of a really interesting topic that Jim mentioned, by way of national security understood as economic security. So I think that, I don't know if incorporating this in the treaties is going to be the solution. And I think that if states want to do so via social licenses, they will find tools to do it in international law as is. And this is just like a little extra angle. The private sector already is having all of these private sector standards. And if you want to be an active player in the private sector, in the mining industry, you are going to be, if you want to be sophisticated, you'll have to comply with myriad standards, and mostly managed by the private sector. So I think that the private sector, consumers, states, we have all a say in where this is going to go. And now the question is whether international law is also going to be part of that, of the actors actively involved in this issue.
Sometimes it takes a while, but we get there. We started a little late, so I'm going to unilaterally say we can go a little bit over, though we won't run into the next session. I would like to open it up for questions from the audience. We have a couple of takers already. Great, this is like an auction. Perfect, 4. Oh, all right, I will be quiet and hand the mic over.
Hi, thank you. I'm Mark. I'm an LLM candidate at Georgetown Law. And so my question really touches on one topic that was addressed very at the beginning of this conference, which was this good faith requirement that has been gaining attention. Is to say that even when the clause, the essential security interest clause in the bilateral investment treaty seems to be self-judging, tribunals would still apply a good faith requirement. So I just wanted to know your thoughts, and so if you know, ultimately states are aware that even when the language is clear in the treaty, they will be subject to this analysis by tribunals.
Hi, it's good. It's a good question. I'm taking a second to think about it, because I generally like the idea, just as a matter of policy, of having good faith review. My problem is it runs up against the idea of self-judging, right? If it's truly self-judging, let's just posit that for a second, and you can parse the language to figure out whether it is or it isn't. If it's truly self-judging, and it's something which says once you invoke, the tribunal has to stop, I don't honestly see much room for a good faith review at that point. The intention clearly was to say the parties invoke, that's it. That may not be a great outcome from an investor protection perspective. May be bad policy, but that's what's written in the regulations. Can I just take? I know we have limited time. I just want to make one general comment as well. Please. So on the question about exceptions, like I don't think a long list of exceptions is necessarily a bad thing, because it gives clarity, right, on some of these things. What bothers me, this is a broader theme of the discussion. What's bothering me these days is what you have a lot of arbitrators doing is saying it's bad policy, so I'm going to find a way to make this case go away, right? I'm going to try to import as much other international law, whether it was contemplated as being applicable or not, or I'm going to import a policy judgment on some of these issues. And I'm not commenting on any of the cases that were discussed on this panel today, because I'm not. But that's the danger. The danger is that you don't have the exceptions. Then what you've got is a delegation of all of this authority to the arbitrators, and they're going to bring in their own political biases or policy biases, and that's a danger to me. It should be the state parties that control, and they should be responsible for being clear in the exceptions in the treaties. And I know that's difficult, and because they aren't very nimble, but I think that has to be the answer.
Great, thank you. We have 1, 2, and we had one over here. So do you still have the microphone up? Oh, perfect. Thank you. You can hear me, right? The button's on the top.
Okay.
Steptoe needs to invest in easy microphones.
Thank you for the presentations. I also have one commentary, or maybe a question that we can talk with James afterwards, after the panel. So my name is Cansu. I worked for the Turkish government for a decade. I negotiated free trade agreements there, negotiated investment chapters. And recently I became an arbitration practitioner, so I might have a view covering both sides. But historically, of course, I was on the state side, always fostering the right to regulate and having, well, it depends on the chapter, it depends on the circumstance, but having some sort of flexible exceptions for the state when you particularly face with a more developed economy as the other party. But after I switched to private practice, it became known to me that some of those exceptions have another danger. That I think that worth a maybe days-long discussion about security exceptions in the FTAs and their effects on investment protection. So before asking your opinion, James, I'd like to make one commentary as an ex-negotiator. So I think that there's also another danger, which is more related to the following. When I started negotiating FTAs, it was the world was supporting trade liberalization, and I was a WTO trained professional, and we were sort of it was like another college, right? You learn the rules by always try to uphold the a more liberal economy or a bilateral trade environment, and that has a reflection on how you implement or interpret exceptions clauses. It could be a general exceptions clause or something else, but you always uphold liberalization. So when we have these exceptions, we didn't know, James mentioned that, we didn't know that they were interpreted in the way that it's been interpreted right now. And now that the WTO is being stalled at the dispute settlement aspect of it, the biggest danger I see is that the political climate right now has the implications of non-applicability of FTAs. So you can see in a smallest quarrel between states, they just sometimes they exaggerate the situation and then completely freeze the implementation of FTAs. And that includes the investment chapter too. I was all for adding investment chapters under the FTA, but right now, I am now an arbitration practitioner. I want them separate because I don't want them to face the fate of the FTAs. When there's something happens between two states, it fundamentally affects the investors' foreseeability for the investments, because I can see that the investors usually have some sort of like a domestic recourse, but they always have the idea that, oh, maybe I shouldn't just, go through with it and go straight to investment protection. But then maybe in a year or so, those mutually loving states are now in a fight, and they say, oh, let's not execute the FTA anymore.
Right, right.
And that actually affects the investment protection. Don't you see that? Are you thinking the same way? I think these exceptions clauses and having those investment protections under the FTAs have this danger also.
This is my question was to me, but
Please
maybe not. Yeah. So I think that danger exists either way, right? Because even if you take the investment chapters out of the FTAs and you put them in, return to a bit, they're going to carry with them the essential security exception. If they're in one place, they're going to be in the other. So that's the danger to my mind. I mean, I don't think. I'm trying to think if there's an example where someone has said, "I'm just not going to apply anything." Well, the FTA is terminated because of essential security. They can do that anyway. But I don't think they've said we're not going to apply any aspect of an FTA because of essential security. Come close, probably on a couple of the more recent measures. But I don't. Well, sorry. I'll try to I'll keep it brief. I don't think it makes much of a difference whether it's in an FTA or out of an FTA. The question is, what is the scope of the exception and how is it applied in any given circumstance?
I think next year we're going to have a whole Washington Arbitration Week on exceptions is what I'm getting out of this. And there's plenty to discuss over lunch. We have had a couple of hands up over here. We have about 10 minutes left before the next session needs to start. So I'm not sure where the mic is. You've got it?
I'll be quick. My name is Baldwin. I've been dealing with economic security type questions for the past couple of years now. So what we see with the proliferation, especially of investment screening mechanisms, is that we're going to see states kind of using and maybe a bit abusing national security exceptions when it comes to foreign investment. And it is already happening in the European Union, where these novel mechanisms for the screening of investments, such as similar to the US CFIUS, are being used in very interesting ways. Of course, within the EU, we don't have investment arbitration anymore, or partially, or it's on its way out, right? It's a long thing. But what is certain is that we will see more of these national security decisions being scrutinized at various tribunals. So We will likely see more investment arbitration cases stemming out of these, especially as these mechanisms can be used to unwind existing investment. But we also see it at the Court of Justice of the European Union that these are scrutinized. And the Court of Justice often uses the necessity and proportionality tests. And I think these will also sift into arbitration as more practitioners of arbitration come from the European Union as well, or are aware of the EU case law. So I think the cross-fertilization in that regard will happen, and we'll see cases where investors might win if the tribunal finds that a particular measure was, maybe it was necessary, but it wasn't proportional to the supposed national security threat that the state had perceived. So it's just a brief comment from my part. Thank you.
Thank you. Gentleman down the end has been quick off the draw the last few times, so.
Thank you very much. Thank you very much to the panel for the very wonderful presentation. Ikeme from Stephen Hoag. I'm into private practice. On the area of the labor exception, right? There are several treaties at the ILO level, multilateral treaties. Now, we all know that labor standards across the world differ, either in Asia, Africa, Europe, or in the America. And these BITs tend to situate the labor standards of condition vis-a-vis the peculiarity of the jurisdiction you're dealing with. There are no cases in this area, but I've had to do some advisory work in this respect. For just recently, just last month, and I was saying to my team that you need to go pull up the ILO conventions. Let's see what they say, because we're dealing with multilateral obligations vis-a-vis national law. Now, from your experience, how do tribunals tend to deal with this, particularly in cases whereby you have claims that relate to harsh labor practices, unacceptable labor practices, and then you have a bilateral treaty obligation, and then you also have the overarching ILO conventions that most countries are signatory to. Thank you.
If you want
Just give
we're going to give a joint response. It's an interesting question, and that touches upon the fragmentation of international law and the role of arbitral tribunals in understanding the fragmented obligations of states to a particular situation. So for international standards, ILO standards, there's not ILO particularly, but for the incorporation of standards in treaties, there's a lot of case law in WTO law, because the treaties in WTO and more for like sanitary measure standards, which are another world, but these treaties, WTO treaties, have different ways of incorporating treaties, and depending on the specific wording, states have to strictly abide by the international standards, or they have to take it into account only as one of the myriad factors taken into account to issue and design the regulation, or they can depart from the international standard. So that is kind of already settled in WTO law, how the wording affects how the standard is incorporated into the treaty. So perhaps this is going to be one of the areas in which investment tribunals might take from WTO panels and the appellate body as to the wording with which parties incorporate ILO standards into these treaties. So it's just to be very careful. What can states do? Only take into account the standard, or they have to strictly comply with the standard? And yeah.
No, not just to direct you to there's the Guatemala case. There's an arbitration that was decided by Ricardo Ramirez, where the US was trying to enforce the labor obligations in Guatemala, and that particularly decision decided whether there was an obligation to strictly enforce labor obligations by Guatemala, and the arbitrator ended up deciding that there was like a best effort obligation, but you can delve into that.
So I'm very sad to say that we have to wrap up. But thank you to our wonderful panelists. I'm sure they will be willing to further discuss over coffee or lunch if there's time. But we should move on to the next panel. But thank you very much for the insights you've given today. It's really been fantastic.